Recognizing the Leader of the Third Party.
Thank you, Honourable Speaker. As I understand it, the members brought forward this bill with the intention of streamlining home building in British Columbia. I do admire the intent of the member, and in this second reading debate, I feel we must consider what damage has occurred under professional reliance. Destruction of riparian areas, forest cut blocks far beyond what was supposed to be allowed under regulations, construction of forestry roads that have undermined water flows and slope stability, a 4-year battle in Shawnigan Lake that uncovered a profit-sharing scheme between the proponents and the qualified professionals, and I will note brought the former leader of the third party into this House. BC Supreme Court Justice Sewell said that this example undermined the integrity of the Environmental Management Act. Last but not least, professional reliance contributed to the Mount Poly mining disaster. A review of the professional reliance scheme under the 2017 Confidence and Supply Agreement found that professional reliance risks oversight and has particular implications for the environmental and Indigenous governments, for the environment and Indigenous governments. The review made 121 recommendations, none of which are covered by this new piece of legislation. The question that needs to be answered by this member and this government is who is protecting the interests of the public when they hand more and more authority over to companies? Who are expected to serve the financial interests of their shareholders and can in fact be sued if they put too much emphasis on environmental or social responsibility. Who is protecting the interests of the public? Under professional reliance, with the government's role cast aside, that protection falls to individuals and communities that feel they have no choice but to step up and do the work of oversight and monitoring that the government no longer does. So, issues with the bill, and I will say I will be listening to this second reading debate and deciding on how to vote along with my colleague, are issues that would need to be raised either in committee or in discussion with the member. First of all, lack of consultation. As far as we understand, this bill hasn't been gone through consultation with local governments or First Nations. This could happen during the committee stage, but that gives only 30 days to occur, which would be a breach of the Declaration on the Rights of Indigenous Peoples Act. There has also not been consultation with the industries affected. While the member is a lawyer and has incorporated the legal perspective, other industries, including engineers and planners, haven't had the chance to have their views heard. It's unclear whether and how this bill will achieve the stated intent of lowering housing costs and getting more housing built. The impact of the local government checking process as a fraction of overall building costs is unclear. I respect the member's view that this will not lead to new bureaucracy. However, the way the legislation is written, asking the superintendent to referee disputes between PGA professionals to me sounds like it could be extremely onerous and expensive and require a lot of resources, with over 150 municipalities potentially sending these disputes to be refereed by the superintendent. Another piece in Section 7 is that professional liability for damages as a what we call known practicing professional engineer, I don't see this possibility of being held professionally liable as a huge disincentive for technical errors. The fact is, this liability is rarely brought to accountability for professionals. As we've seen with Mount Poly, nobody's gone to jail. Fines are minimal. When it comes to disallowing peer reviews, I'll just relate an example from my time on council in the town of Gibsons. We had a proposal for a large building that would have potentially have done damage to the drinking water aquifer that supplies the entire town. We relied on peer review by professionals to protect against that eventuality. And it was absolutely essential to protecting one of the key natural assets of that community. I'm having a bit of difficulty distinguishing between a peer review and a PGA or professional employed by the local government. To me, those are very similar things. So I'm not sure why we disallow peer review when these local governments need to. Smaller communities, smaller local governments just don't have the resources clearly in-house assess some of these projects. So they need to employ a professional to do that. How that's different for peer review I need to understand. I would love to, most professionals are technically competent, have all the right intentions. I would love to build in that trust. However, there are a few bad actors there who, which is the reason for the need for regulation. I would like to see because I support the intent, I would like to see if there's a way to amend this bill to allow local governments to maintain some of that autonomy without slowing things down. It's not clear to me that it is local governments that are necessarily the ones standing in the way of quicker construction of homes. But it is very difficult to support the removal of the ability of local governments to decide and referring it to a superintendent, as we said, sitting in Victoria, who doesn't know local conditions. In the case of Gibson's, the technical understanding of the aquifer was absolutely key, and having it decided by a superintendent outside of the community was not feasible and may have produced an entirely different outcome. So, as mentioned, I will continue to listen to perspectives. I have an open mind, but there are some serious concerns that both my colleague and I have with this bill, and thank you for the ability to comment.